This is Beyond a Reasonable Doubt with your hosts, Mark Garrigus and Adam Carolla.
Yeah, get it on. Got to get on a choice. Going to get it on, and welcome to the best quarter hour or so in the universe. It's Reasonable Doubt. I'm Adam Carolla. It's Mark Garrigus, fresh off his triumphant wedding of his beautiful daughter. What an event. What a night. Thank you so much.
Oh, my God. Having you next to me and Gary at the next two tables over was about as perfect as could be. What an enjoyable evening. You, Drew, me, Gary was actually like a Carolla podcasting Mac or DJ fest. So it was wonderful, and thank you.
It was a wonderful night. We'll get into it in some more detail and have some laughs about it during a reasonable doubt of regular length. But beyond, right. We're pressed for time, so I feel like we should just jump right into. We got Cosby, something we were talking about for a long time. We have other cases.
There's an interesting case that I had pointed out because when I read the U.S. Supreme Court did not take this case, but the Gorsuch, Thomas, and Alito said that they should. And if you look at the reasoning of this, it's right up your alley. It's as if you were mind melding with these three guys, and it has to do with defamation, and it has to do with public figure and the malice standard, which has been the standard since, I believe, 1964 in the case New York Times versus Sullivan. And the case was brought by a gentleman who's basically was the subject of a book that was made into the movie War Dogs with Jonah Hill. Did you ever see that?
Yeah, I did, where he played the character that was an arms dealer. And, first off, I hope the guy was fat, because if he wasn't fat, then that's a whole separate lawsuit there. But the guys were drug addicts and dealing arms and doing all sorts of nefarious shit.
And so they didn't take his case. And the Gorsuch has a line in there. Gary, you want to read it, and I'll pivot off of it because it was an interesting kind of a take on this. Mind you, previously it was only Justice Thomas who was arguing that they should revisit New York Times versus Sullivan. He's now got 3 votes. I'm going to guess that sometime very soon he's going to have a 4th vote. And when he gets the 4th vote, I think New York Times versus Sullivan and the malice standard for public figures is going to be eliminated. But Gary, read the quote. And then I want to talk about something kind of interesting, given the polarization of our society as we sit here.
The quote from Gorsuch was, quote, "Not only has the doctrine evolved into a subsidy for published falsehoods on a scale no one could have foreseen, it has come to leave far more people without redress than anyone could have predicted."
A subsidy.
Yeah, and basically, yeah. A subsidy, because and Thomas points out also what has happened is, and this is what I've been arguing for, by the way, another case, Supreme Court case that was decided 10 years before, which was Shepard versus Maxwell. The environment in the 50s and the 60s is not the environment we're in today, in terms of media. And Shepard versus Maxwell, which was pretrial media in criminal cases, which is the seminal case, and New York Times versus Sullivan, which is the seminal case in defamation libel. They really have been perverted. Both have been perverted. And that's what they're arguing, or at least the conservative wing, ironically, is arguing that it be revisited. And I say ironic for a couple of reasons. Number one, the conservative wing generally does not like judicial activism or this idea of a living constitution. Number two, even more ironically, they cite the Pizzagate case, or Thomas has, as an example. The pizza parlor with Hillary Clinton running a pedophile ring out of it. Thomas actually, Gary, do you have that when he talks about that as well?
Yeah, I mean, he generally spoke about the conspiracy theory surrounding the Washington pizzeria, and then he also referenced a lawsuit involving Bill Cosby when a woman said that he had called her a liar, and after she accused him of rape. So he cites both of those, though the quote's not right here.
And Adam, what you zoned in on is he says it's now kind of profitable. It's become profitable to traffic in lies, because you can get eyeballs. Basically, I assume what he's saying. He didn't say this. I'm interpreting it. You can get attention. You can get, you can monetize that, so to speak. And basically what you've done is you've given people a free pass to lie in order to monetize it. And by doing that, there's no redress, which is something that you've been complaining about on this show for 6 years.
Well, I think there's a distinction to me whether you're lying because you made a mistake and you didn't have information, or you're lying volitionally. You know, I guess we get back to the Nicholas Sandmann case, where that he's getting paid now because it was pretty clear that they kind of cooked the video and they ran with it. And then also, I think the distinction is the difference between a public figure and a private citizen. So when you're Mark Garrigus or you're Adam Carolla, you're Jimmy Kimmel, or you're, Mayor Garcetti, people are allowed to talk shit about you because you're in the public view. But if you're a citizen and you get your reputation smeared and tarnished with lies, and in today's society, potentially, if you're a 16-year-old kid like Nicholas Sandmann, potentially unemployable. I mean, we're now at the point where good luck getting into Stanford, even if you had the grades and the SAT scores, if you're that kid and this is your legacy. So now we're getting into a monetary thing here, because it's definitely affecting your livelihood. If you want to run for mayor or you want to be a Hollywood action star, then you've stepped outside of your protective bubble, and even then you can go back and sue. But I think the standard is much lower if you're a civilian. But you can speak to that, Mark.
Yeah, that's exactly what they're saying. They're saying just because you can take pot shots at somebody because they're a public figure, and you've got the bar of malice in order to hold them accountable, and people can, throw bric-a-bracs at you or me or somebody else. And the only way that you can kind of seek redress is if you show malice, which, by the way, you can. I'm not saying it's an impossible standard, but it's a much harder standard. And basically what they're saying is you shouldn't reward it. And that, I think, is at least it's starting to get critical mass. And I think I'm going to predict within the next term or 2 terms, you're going to see a case that presents itself that they take. And I think New York Times versus Sullivan is going to get, if not sufficiently watered down, it's going to get basically overturned. And that is going to open up the floodgates. I think you're going to see something that's more akin to the UK.
Well, what is the New York Times versus Sullivan? Sullivan wanted to go after the New York Times for defamation?
Correct. And they said the only way you could do it is if you showed there was actual malice in layman's terms, but malice meaning that not the traditional vex, annoy, harass that you get from malicious mischief, but malice, not the standard for separating manslaughter from murder, but they had to show that it was a higher hurdle. And it's just interesting to me that they invoke Pizzagate and Hillary Clinton and talk about and specifically say the damage that could be done. And it's only, once again, it's only the 3, what are called the 3 conservatives. I keep looking at this court as a 3-3-3 combination. Those 3 are on the right. Interestingly, another little tidbit that you could speculate on today. I had also sent this over to Gary. There's a movement on the left to get Justice Breyer to retire because they want Joe Biden. But I will tell you that given what the news that was just released this morning, that he's set up his clerks for next year, and he's named who the clerks are, I think that is not going to happen. And so I think that's no longer up for a reasonable discussion reading the tea leaves here. I don't think he's going to retire. And by the way, I think it's probably smart if you're on the left, because he's got so much institutional knowledge and he's got the relationships there that he's able to do things that if he was replaced by somebody who didn't have that both institutional knowledge and the relationships, could not, I don't think, form the kinds of collegial bargaining, so to speak, that goes on or is reported to go on in behind closed doors at the Supreme Court. A lot of machinations going on at the U.S. Supreme Court. A lot of, I think, in this last term and in the last days, a lot of surprises as well.
What do you think's going to happen? You know, the New York Times is still around, but really, the big tech has become the New York Times, or a much more broader reaching version of the New York Times, even than when the New York Times was, you know, the paper of record back when the case we cited came down. What about all the doctors who said, you know, here are therapeutics that work, and or here's where I believe the virus leaked from a lab, and they were essentially labeled with misinformation, said they were quacks and, you know, deplatformed. They could argue that their reputations were very, very much injured by these big tech platforms, and there's certainly a monetary aspect to having your reputation tarnished as a physician. Is there going to be a new class of lawsuits that come out against big tech, especially vis-a-vis this like COVID and misinformation and all this kind of stuff that came out, you know, a year ago?
The way that the cases evolve and the way the U.S. Supreme Court takes cases, it would not surprise me also if in the next term or term after you see some case make its way up, that because it'll probably be on a fast track, because some district court judge will dismiss it, it'll go up, it won't get reversed, and then they'll take a certiorari to the U.S. Supreme Court. It would not surprise me in the least if you saw a case that starts to define or at least get into and deal with some of the nuances that we've talked about. I think that's where we're headed. I just the pendulum swing seems to be going in that direction now. There seems to be a substantial shift in the thinking. You and Drew at the wedding, we're talking about kind of this pendulum swing that we're watching happen, and part of with the opening up and the recall going on here in California that we're close to. I think there's going to be some surprises in store. I really do.
Can we talk about Cosby for a couple minutes?
Yeah.
So he was let off, some people say on a technicality, sort of based on something we were talking about for a couple of years. I think a lot of people's mindset is, well, he said he did this, so who cares if he's in jail, because he basically admitted to it. It's kind of saying, well, the guy had an illegal wiretap, and the feds recorded the guy saying he murdered his wife, but the wiretap didn't have a warrant, and so we got to throw it out. And I think most Americans go, look, the guy said he killed his wife, then he killed his wife, he should rot in prison. But tell us why that's not a good idea in this case.
Well, yeah, I bristle at the idea of technicality, because for the same people who may call it a technicality are also the same people who revere the Bill of Rights and the Constitution. The Fifth Amendment is there for a reason. It's there because we've decided in our system, in a criminal case, the onus, the burden of proof is on the prosecution. They're the ones who have to prove the case. You don't have to defend yourself. There are other systems. You can go to the French system. I can cite a number of systems where that isn't the case. But here in America, the prosecution has to prove it beyond a reasonable doubt, and they cannot force you to testify. That's in essence what happened here. They forced him to testify by this prosecutorial bait and switch. They had a prosecutor, Bruce Castor, who promised that he was not going to prosecute Cosby, and that the case was, in his words, he testified to this, it wasn't me. His words were, it's not going to get any better over time, so I'm telling you, this case is never going to get prosecuted. Therefore, Mr. Cosby, you cannot assert the Fifth and avoid testifying in your civil lawsuit. My guess is if we had Bruce Castor on here, he would tell you I was doing that on behalf of Andrea Constand, the victim. I was trying to help her get some measure of justice because I didn't think I could convict him. And guess what? At that point, he couldn't convict Cosby because he didn't have Cosby's testimony. He did not testify. So it made perfect sense. Well, when Bruce Castor said that, then Cosby no longer had the ability to assert the Fifth Amendment. He did testify in a deposition. The civil case was settled after that. The deposition was sealed. Fast forward 15 years later, 13 years later, a federal judge unsealed it. And the new DA, who had basically campaigned on the idea of I'm going to prosecute Bill Cosby, then prosecuted him not once but twice, hung jury the first time, convicted him. And then the Pennsylvania Supreme Court, mind you, it was only 4-3. One vote would have separated from coming and going. But the Pennsylvania Supreme Court said, you can't do this, and we're not going to let you prosecute him again. You're barred. That's it.
Didn't the DA know this was going to happen several years ago?
Yeah, I have a theory on sometimes because I often have sat and wondered why lawyers do what they do sometimes. Sometimes I think the skeptic or the cynic in me thinks that prosecutors don't really care because they figure they're going to move on to bigger and better things. And nobody's going to care when it gets reversed years later by some court down the road because they will have moved on to a congressional seat or a governorship or a senatorship, and they're no longer a prosecutor.
So is he still a prosecutor? And
he's around.
What's the aftermath other than reputation?
Well, we talked about this on Beyond a Reasonable Doubt. Cosby's almost certainly now going to sue the municipalities, and there's a real way to prove lost income. So this could end up with a state or a county paying quite a bit of money.
Do you think he's going to get a big check out of this?
I think it's entirely possible that he gets compensated. Yeah, I do.
All right, Mark, that's it for the short version of our show, but we'll be back with a full-length.
Adam, it always goes too fast.
Too fast. We'll be back with a full-length episode soon, and we'll get into all the nuts and the bolts. So, until next time,
guys.
This is Adam Crow from Mark Garagos saying mahalo.
Thanks for listening to Beyond a Reasonable Doubt. Stay tuned for more bonus episodes coming soon.